Hi, my name's Denise Vansant. I'm the broker at Vansant Realty Group here in Myrtle Beach, South Carolina. And today I have with me Emily Lary. She is a real estate attorney with Tide Law Firm in North Myrtle Beach. And she is here today to talk about probate and and the real estate process. So welcome.
Thank you. I'm so glad to be here. I hate to say yay about talking about probate, but it's yay from the aspect of it's really great when people know what they're getting into and what they're going to be dealing with. So my goal is to just provide some education. This is not to be construed as legal advice, and I'm not your attorney because you're listening to this. But if you have any questions, or you want to form that relationship, please reach out to me.
So today, Emily, we're going to talk about probate specifically.
Okay.
Because being a realtor, oftentimes I will have questions from families where they're facing the selling. They need to put the house on the market after a loved one has passed, and they don't know the process. So I think it's a really good topic for us to talk about today and kind of enlighten people of what the whole probate process is and how to sell real estate during this time.
Okay, yeah. So this would largely pertain to sellers, right? So you're listing the property and putting the house up for sale. So for starters, they would have to start and open probate, which means that they have to file a copy of the will and the death certificate with the probate court here in Horry County to get the estate going. And generally speaking, probate is the process in which a deceased person's assets are distributed to their heirs, and it's the court's oversight of that process, going through that to make sure that either the decedent's will is followed or the laws of South Carolina are followed in the administration of the estate.
So Emily, most often people who are facing this situation is oftentimes their very first time. They don't know what to do. Let's say, for instance, which often happens here in Myrtle Beach because we're a resort type community. Oftentimes people own a second property and they live in a different state. So do they need to file their probate in their home state as well as here?
So that's actually a really difficult question to answer because it's really situation specific. So let's say that a person owns property in multiple states. The person lives in another state, and they have probate assets that have to be taken care of in the state they live in. Then I would say that they would open probate in their home state where they lived. Mm-hmm. Versus if a person lives in another state but doesn't have any probate assets in that state and they only own property in South Carolina that needs to be taken care of, then I would recommend that they open probate here in South Carolina. But they would have an option as to what state they can open it in because they lived in another state. And so a lot of times it falls on the personal representative to decide what's most convenient for them.
What is a personal representative? Can you explain that a little bit?
Yes. So a personal representative, also known as the executor of an estate, that's the person who's in charge of filing the probate with the court. So they're named in the will. And if you don't have a will, then the court appoints somebody, typically, your spouse or one of your children or a close relative. They can decide who is going to serve in that position, and if nobody wants to decide, then the court will decide. But so your personal representative is in charge of handling everything from start to finish to make sure that all the assets are taken care of and that all the proceeds and everything is given out to all the beneficiaries.
Mm-hmm. So in South Carolina, correct me if I misstate this, but in South Carolina, when you die with a will and you want to file probate for real estate for your home, you want to sell your home, but the property is co-owned by it's owned by more than one person. There's another owner. Then they actually inherit the entire property. Is that not correct?
With a will And did you say a spouse?
A spouse or someone that they co-own the property with, it's on the title.
Okay, so it just depends on if they have title held as joint tenants with rights of survivorship or tenants in common with the indestructible right of survivorship. If they have one of those two survivorship interests in the property, then yes, the spouse will automatically inherit or own the property outright 100%. You just have to record a death certificate with the county, which we can do at closing or it can be done prior to.
Okay, so that really means that they go ahead and sell that property and the money is theirs at that point at closing.
Correct, yeah. So it would be technically called a non-probate asset because it's held, the other spouse automatically owns the deceased spouse's interest.
Now, if someone passes without that situation, they're the only owner on the property, they're not married, there's no joint tenancy involved, then they need to file the probate, and that's when the whole probate process starts, and any proceeds from the house, which you can sell during probate, would then be put into a special estate fund, correct?
Yes, yeah. Essentially, if the house is sold out of probate, instead of having it transferred to the beneficiaries prior to the sale, then yes, the funds would go back to the estate and not to the beneficiaries directly. And then after the probate is finished, then the estate would pay the beneficiaries.
Now, so would you advise your clients, and I typically advise my clients, if they're in a situation, to go and find a real estate attorney, and I work with a lot of them. We've done lots of different types of probate transactions here in the Myrtle Beach area. It's best advised to work with a real estate attorney and do this, as well as if it's an involved estate, an estate attorney?
Yes, so ideally, like for real estate agents and for your clients, before you even like sign a listing agreement and that sort of thing, if you know that you're going to be dealing with an estate selling property, I highly recommend that you just go ahead and take what you have to who you intend to work with, real estate attorney wise, just so they can review all your documentation to make sure you have everything in order to ensure the transaction will go smoothly and that you're not missing anything that could come up.
Right, because one of the things, I mean, when we get to that point, when someone comes and asks us, hey, can you list my house for me? Can you list this home? It's not, we ask them, is it in probate? And if they say no, then we don't have a personal representative that can sign the listing agreements.
Right. Yeah, you don't have anyone that can sign any agreements. They can't sign the contract, nothing, because nobody's been authorized to represent the estate. So you have to have the personal representative appointed through probate by the probate judge. They have to go ahead and appoint that person, and then you can enter into all these agreements.
Correct. So once this whole thing is put into motion, and the clients then come and they ask you to file the probate paperwork for them, and they present you with the decedent's will, you start the whole process. How long would you say it takes, once the process is started, for a personal representative to be appointed?
That is also a difficult question to answer. So it really just depends. I think it takes, I'd say give it at least a month. The probate court's kind of slow. No offense to the probate court if you're listening, but they do it. They have a lot to do. So I'd say give it about a month for the PR to get appointed, because there's a lot of paperwork that has to be filed and go through and be approved and all that. So I'd say get started as soon as, if you know that you're going to have probate assets, then go ahead and start that process getting appointed, so that way you can start getting work done.
And how long would you guesstimate the entire process starts from start to finish? We've sold the home, the money has now gone into an estate fund. When, typically, what's the length of time?
So an uncontested estate, so a very simple estate, nobody's challenging anything, it's going smooth, I'd say 8 months to a year. Through the whole probate process. Now, it can get very lengthy depending on the complexity of the state and how many heirs there are, and how many assets they have, and all. There's a number of factors that can go into play. But a very straightforward, simple estate can, I'd say, at minimum 8 months, but you're probably looking at about a year. We were talking about ownership and joint tenants with rights of survivorship and tenants in common with the indestructible right of survivorship. So those are the two ways to have property pass outside of probate through the deed. But their
point.
other option, and one that we come across, is tenants in common with rights of survivors, with tenants in common, just tenants in common. When two people own property as tenants in common, then each person's ownership interest is subject to probate if one of them dies. So that person's 50% interest, if it's 50, it can be delineated like 5%, 2%, 1%, you know, but we'll default to 50%. That person's 50% interest, if they die, is subject to probate. So that one person who's still alive cannot sell the property until this person's probate has been dealt with, opened, started, and a PR has been appointed and all that. So the person who survives can only sell their 50% interest.
That's a very interesting point, a very good point.
Yes. So that's something that we kind of look for. So if I have a spouse reach out to me and saying, you know, my husband died, I'd really like to sell my property, can I do it? I'm like, well, first let's look at your deed. Let's see what's going on with your deed, make sure, you know, that you had survivorship rights, and if you didn't, then I'll tell you what to do next.
Let's say that they die intestate. That means they die without a will. And there is a husband, let's say the wife dies, and the husband is a survivor, but there is no will. And would the property have to be held in joint tenancy for him to receive the entire house? Or even if, since there's no will, would the children also get half of it?
So if there's survivorship rights, then whoever's named as the survivor would get the property 100%. If there's no survivorship rights and no will, then technically the South Carolina law says that the spouse is entitled to 50% and the children are entitled to 50%. So that brings your children into the mix too, and it kind of complicates the situation.
Which is a very good reason for people to go out and get a will.
Absolutely, yes.
Plan ahead. You never know what tomorrow holds. Get your will.
Right. Now, I always recommend that people get a will, and some people, you know, it's very straightforward. They want whatever intestacy would happen anyways, but it really expedites the process when you have a will. Because the powers that the PR will need to get everything done are given to the personal representative through the will. So, for example, if you don't have a will and you want to sell the property that was owned by a person who passed, then the personal representative has to petition the court to get the power to sell the property. So that can take also another month or two added onto there, and it really slows down the process. Another thing is we come across wills that where the PR hasn't been given the power to sell the property. And if that's the instance, then they would also have to petition the court to sell. But most wills made these days all explicitly grant the power to sell to the personal representative. So I want to circle back to intestacy real quick and just talk about some options that come up with intestacy. So when you have somebody who doesn't have a will, like I mentioned that the personal representative will have to petition the court for a power to sell the property if they want to sell it through the estate. There's another option that can be a viable option to expedite the process if you have an intestate estate, and that's the option to do a deed of distribution to the heirs. So a deed of distribution is just a document that releases the property from the estate to the intended beneficiaries. And what we can do is, as long as the probate application's been filed and, you know, you're probably about halfway through or a couple months into the process, the heirs have been identified as to who's going to be the beneficiaries of this deceased person's assets. What we can do is prepare this deed of distribution to those heirs, and then those heirs can then in turn sell the property themselves, as opposed to waiting for the court to give your petition your order to sell the property. So that can be a viable option. There are some downsides to it, some tax consequences, which I'm not going to get into because I'm not a tax attorney or or an accountant. But it can be a viable option for some people, especially if they're trying to get this done and expedite the process.
Would there be any reason that a deed of distribution could not be filed?
So some things to consider in preparing a deed of distribution is that once the deed of distribution transfers the property to the heirs, if the heirs have any judgments against them or anything like that, then those will all attach to the property at that time. So if somebody knows that they owe money, they have a judgment against them for unpaid credit card debt or a tax lien, or, you know, they got sued and somebody's waiting to get paid from them, then it may not be a viable option for that purpose. So it really just, it's situation specific, and also it's not that a deed of distribution couldn't be given, it just may not be desirable.
Gotcha.
So deeds of distribution are prepared also when you have a will. Deeds of distribution release the property from the estate to those intended beneficiaries as well. So it really just depends. If somebody wants the property as opposed to selling it, then they'll get a deed of distribution. If they want to sell the property through the estate and get the proceeds, so it's really just, it just depends. And it also depends on how much money the estate has. Because if the estate is insolvent and all the money is going to be coming from the sale of this property, then they're probably going to want to keep the property in the estate and sell it through the estate. So there's some of the few considerations of many that go into how the property should be sold when it comes to a deceased party.
That's the importance of working with the right attorney.
Right attorney and the right realtor.
Exactly.
Who knows what they're talking about.
This is true. So you made me think about another type of situation.
Okay.
Someone planning ahead, they want to do a will, but you know, maybe they're worried that they're going to come down with dementia or become incapacitated in some way. And when they get to that point, they don't want their children to be saddled with the house and having to sell and go through that whole process. How would something like that be handled?
So there's a couple ways you can go about it. First off, I would highly recommend that you get a durable power of attorney executed. Power of attorney will allow somebody to deal with your affairs while you're alive. So it's a financial power of attorney, and presenting that document alone can help facilitate and allow whoever it is that you nominate to be able to take care of all these things without having to go through a court and be nominated to take care of that for you. The other option, you can put your property in trust. You can establish a trust and nominate your trustee who will step in once you become incapacitated, and your trustee of your trust can take care of all those things for you.
So as a realtor, and if I came across a situation like that where the family has a property in trust or something that you just described, what would the designated person be then called? They wouldn't be a personal representative any longer. Would they be a power of attorney that I would be looking to have
Yes.
as a signature?
Right. So you'd want you'd want to get a copy of the power of attorney, either recorded or original, is something that we would require for our records, and they would be called the power of attorney. So you'd have so and so as power of attorney for so and so. Now your trustee, it would be the trustee of the trust, whatever the name of the trust is, who would be responsible, and that would be signing the documents, and that would be who's selling the property and so forth. Just to touch on quickly, if somebody does become incapacitated and they don't have their property in trust and they don't have a power of attorney, the loved ones or, trusted family members can petition the court to either be appointed as power of attorney or to be appointed as a conservator or a guardian. That's a whole nother process that I'm not necessarily qualified to explain to you, but those are other options. You're not completely out of luck if this is your if this is your situation or your seller. There are things that you can do, but I would definitely entertain that process before you ever list the property, because it can also be a lengthy process and slow things down. So I would definitely want to get that checked out first and just talk to somebody, a probate attorney. A lot of probate attorneys can do conservatorships and guardianships and the court-appointed powers of attorney.
Going back to probate, the house is part of the probate assets. What about the furniture inside the house or the car in the driveway? Is that considered a probate asset?
Yes, it would all be considered probate. It still follows the same distribution scheme that's in the will if you have one, and if not, then it's just divided in the same distribution scheme that the South Carolina law outlines. So 50-50 spouse and children.
Yeah, because a lot of times I'll see estate sales here, and I don't know that they've necessarily filed probate. I'll see the big sign estate sale, and they have someone in there, and they're selling off all the furniture, and the house might not be yet assigned a personal representative, and I don't even know if they've gone through the probate process, but I know I see that. So a really good idea is, we just need to get that probate process started first and then take care of that other type of business.
Right, yeah. So a lot of times if they are having an estate sale, ideally all those proceeds should go back to the estate and not into their pockets. But you don't know what people are doing. Now, there's not as much oversight on the personal property stuff, except for cars. The DMV, to sign a car title over, the DMV will require your personal representative appointment papers to sign a car title over. So you'll have to do that. But as for like furnishings and stuff, I think that's more so dealt with.
So, Emily, what do you think the most important things are that people should, just to kind of summarize everything, tell the audience the most important things that they should consider when they're going through this experience?
Okay, so we'll start high level. First off, let's look at the deed. Take a look at the deed, find out if there's survivorship interest, and who actually owns the property. Do we need to go through probate, or are we good to sell as is? If we have to go through probate, then I would look for the will. You have to file an original will with probate along with an original death certificate. So gather those two things and head to the probate court or head to a probate attorney, one or the other. If you have a lot of questions and you really need help, I'd suggest going to a probate attorney first. Once you get probate started, probate court will guide you through the process. That's very form driven. They'll tell you what forms to fill out at what time and what you need to do and when you need to do it by. Get probate started. Once you have probate started, then let your realtor know, hey, I've got probate started. Hey, I've got my personal representative appointment. We're ready to do this thing. From there, you should be good to go. If you have a will, we're looking for the power to sell. If you don't have a will, you have to petition the court for a power to sell the property. And that should really touch on a lot of your probate issues that you come across. Those are the big things that we come across. I don't want to say every day because we don't deal with the states every day, but we deal with the states a lot. And those are the most crucial things that come up whenever we're trying to get a property sold out of probate.
That's a great summary and touches on everything. And, when you find yourself in this position, you're going to be all of a sudden looking for a realtor. And it's really important that you interview your realtor, because not all of us have the same level of experience, and we all bring different things to the table. So you might want to ask them, have you ever handled a probate estate, and what's involved in it? And what attorneys do you work with that can help me through this process? Emily, it has been an absolute pleasure having you with us today. It was very informative, and I'm sure our audience will absolutely treasure everything that you've had to tell them and take it into consideration for future reference should they ever come across this situation that they're in. So I want to say thank you.
Thank you so much for having me. It's been a pleasure doing this, and I'm excited to be a part of this. And hopefully we can come back again and share some more knowledge with your followers.
Sure. And if you ever have any questions about selling your real estate, getting your property on the market, and need realtor advice or attorney advice, we're here to help you. My name's Denise Vansant, Vansant Realty Group here in Myrtle Beach.
Emily Lary with Tide Law Firm in our North Myrtle Beach location. Come ride with the tide.
Thanks for tuning in.